Hi, Advocate Rishabh.
Hi.
Sir, on the 2nd of November, the Honorable Supreme Court of India has held that the RERA Act does not bar remedies under the Consumer Protection Act. Could you please help me understand what this update means, sir?
This update is really a big relief to the home buyers. The Supreme Court yesterday, in an important judgment, said that despite RERA being in place, the home buyers can approach consumer courts for complaints. This even includes receiving compensation and refunds from the developers in getting delay delay in getting possession. The bench of justices UU Lalit and Saran Verma and Vinit Saran in their 45-page judgment have rejected the plea of Messrs. Imperial Structures Limited on the ground that wherein they had mentioned that since the RERA has come in place, the National Consumer Redressal Commission cannot give judgments on those grounds.
Okay.
In this particular case, if you take a look at Section 18 of the RERA Act, wherein it clearly mentions that in case the promoter fails to complete or is unable to give possession of an apartment by the date specified in the agreement, the promoter is liable to return the money on demand with respect to that apartment, and if the allottee wishes to withdraw from the project, this right to withdraw the allottee has got without prejudice to any other remedy available to him. Thus you can clearly see RERA provides a remedy to the allottee who wishes to withdraw from the project or claim and return on his investment. In this particular case where this judgment was passed, the
Mm-hmm.
facts, I would like to apprise you with the facts of the case.
Sure, sir.
The consumers who had approached the National Consumer Dispute Redressal Commission had booked the flat in 2011-12.
Mm-hmm.
Their flat was costing approximately 75 lakhs, and they were promised that their flats will be completed in 42 months from the date they have made the payment, and each buyer has paid around 63 to 65 lakhs, that is more than 75% of the amount what they had to actually pay for the entire consideration.
Mm-hmm.
And after 4 years of even after 4 years, when they went to the site, there was no progress happening. It was still the same way, the how they had seen the land when they had booked the flat. After that, in 2017, they approached the NCDRC, and after they approached the NCDRC, the NCDRC passed an order in 2018, wherein they had given an order to return the money within 4 weeks at the rate of 9% per annum to the developer. The de- to the developer, and the developer was also asked to refund an amount of rupees 50,000 of the legal fees paid by the consumers. So in this particular case, you can also see that there is a section in RERA, that is section 79, which
Mm-hmm.
mentions that section which mentions that uh, section 79 bars jurisdiction of a civil court to entertain any suit or proceeding in respect of the matter which the authority, adjudicating officer, or appellate tribunal is empowered under the RERA Act to determine the particular case. Then the section 79 further also does not mention clearly. In simple words, I would like to tell you that section 79 does not in any way prohibit any commission or forum from hearing a complaint under the provisions of the Consumer Protection Act. So from this you can very well see that if in these particular cases the developers are taking a stand that since the consumer protection act does not fall in place, the consumers have to approach only RERA and they will not have any other option.
Mhm.
But in this, once you go through the whole judgment, it is very clearly mentioned that the consumer has the right to choose where he wants to approach for the redressal of his grievance. This in this particular case, the consumers have approached the National Consumers Dispute Redressal Commission, and they have received the order in their favor, and the developer has gone to the Supreme Court challenging this particular order. And when this order was heard by the honorable justices, so all these points which I have mentioned have come into light. And even in the particular order, the Supreme Court has clearly mentioned that even if the Consumer Protection Act did not want the real estate buyers or the real estate consumers to come under their purview, so they would have clearly mentioned in the Consumer Protection 2019 Act, which they did not do so. So
Correct.
it clearly mentions that the parliament had an intent, which is clear, that the choice is of the allottee and not of the developer. It is the allottee who has to decide whether they have to approach the RERA or they have to approach the Consumer Protection Act. In this particular scenario, the home buyers will they have to be very carefully understand that how where will their grievance be answered in a particular way, that they understand the 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 commission understands their case, and
Right.
they will have an uh, and the order will be passed accordingly.
Correct. Thank you so much for this, sir. It has been very, very helpful and very educative for us and for
Thank
our
you.
viewers as well. Thank you
Thank
for
you
your
very
time.
much. Thank you.